Good morning, ladies and gentlemen. I'm Mapula Mkabela, Ms. Mkabela, and I'll be presenting your first discussion class for the module Civil Procedure, module called CIV3701. Welcome to the first discussion class, and these sessions are recorded in order to ensure effective processes and authorized by the university regarding online discussion classes, and for the recordings to be uploaded on my UNISA platform and accessed later. Kindly note that today's session is based on the first two study units of part 1 of your study guide, which are the Introduction to Civil Procedure and Sources of Civil Procedural Law, and it's also an orientation of the module. I'll be sharing my screen just now. Please hold. Please hold on 1 minute. I was just trying to get my PowerPoint presentation ready for you guys. Okay, here we go. Okay, please hold for me. I'm almost there. Oh my gosh. Okay, let me just adjust my screen. Okay, there. Okay, okay. Ladies and gentlemen, the aim of these discussion classes is to assist you to achieve a better understanding of the course material and matters under discussion, and the objective is to promote a successful completion of the module. The tutorial matters are designed, okay, let me get to the next screen, next PowerPoint, sorry. The tutorial matters are designed to provide sufficient support, and every aspect may not be overlooked in preparation for your assignments and ultimately your exams. Complete your assignments and study feedbacks and commentaries for assignments carefully in preparation for your exams. Please study all study units for exams, and if any aspects for a particular section is not covered in the discussion classes, it doesn't mean that it will not be tested in the exam. Go through activities and feedbacks to gain a clear understanding of the module. Ladies and gentlemen, the prescribed book for this module, CIV3701, is Civil Procedure, a Practical Guide, 3rd edition. What is civil procedure? Okay, getting to the next slide. Okay, ladies and gentlemen, let me just prepare myself properly. Okay, civil procedure in South Africa is the formal rules and standards that courts follow when adjudicating a civil court case, as opposed to procedures in criminal law matters. These rules of civil procedure governs how a court case may be commenced and what kind of service of process is required. Where the nature of a claim requires you to institute, the nature of a claim requires you to institute an action proceedings, or a motion proceedings as the correct form of proceedings or a legal action against someone. Please take note that motion proceedings may also be referred to as application proceedings. Moving along, ladies and gentlemen, action proceedings has two types of summons. They are your simple and combined summons. Using a simple or combined summons depends on whether you are suing for money or an action for a divorce, or even a claim for damages. Application proceedings has four types of applications, and they are ordinary application, ex parte application, urgent application, interlocutory application. The motion proceedings is founded on a right that has been violated and you want to protect or enforce a right, for example, for defamation claims. Briefly in this module, the learning outcomes are as follows. Excuse me, ladies and gentlemen. I'm behind with my slides. Please excuse me for this. Okay, on this slide that we are on, it's showing your action proceedings with your simple summons, and the nature is either a debt or liquidated claim, and combined summons, the nature is a claim for damages or action for divorce. And with your motion applications, there are four types of applications, which are your ordinary application, ex parte application, urgent application, and interlocutory application. And as I explained, ladies and gentlemen, the nature is where your right has been violated. Now, the learning outcomes for this module is that an understanding of the rules and principles of civil procedure, and explain the choice of appropriate procedure, demonstrate the ability to meet and overcome various procedural obstacles in practice, and ultimately to demonstrate your ability to present solution to problems through theoretically founded arguments. In order to litigate successfully, these important procedures are to determine the correct form of proceedings or a legal action taken against someone, the correct documents to be prepared and filed in court, their method of service, the conduct of proceedings in court, and whether the order is subject to an appeal or a review. Ladies and gentlemen, here is just a brief learning outcome of the module, what you are expected to be to acquaint yourself with. Now, on the structure of the study guide, the tutorial matters for civil procedure is divided into part 1, which is your introductory studies. Part 2 will be your jurisdiction. Part 3 is your court procedure, and part 4 will be variation of judgments, review, and appeal. And of course, the study units, which forms part of the core of the study guides, are subdivided into sub-units. Okay, to gain maximum benefit from the study guide, it is important, ladies and gentlemen, that you understand how each study unit have been structured, and because they each deal with a specific aspect of the tutorial matter. How each study unit consists of is an overview, which is a brief summary of what the study unit is all about. such as a description and analysis of a particular jurisdictional principle, procedure, and processes. There is also a system of cross-referencing to other study units, which will enable you to place the particular principle, procedure, or process in the context of its jurisdictional or procedural relevance as a whole, and on the other hand, to determine the relevance of each principle, process, or procedure within the framework of civil procedure, and to facilitate or to help with a cross-referencing. The study units have been numbered and repeatedly from the beginning of to the end of the study guide. Now, the learning outcomes of the civil procedure module. These are study objectives, or you can say purposes, or even aims for a particular unit, study unit, which are there to demonstrate to you as a student what information is contained in that specific study unit in order to enable you to start out with a clear understanding or idea of what you are expected to learn from each individual study unit. There's also a reference to compulsory reading material. Ladies and gentlemen, it states in your study guide that this does not mean that you need to memorize the court rules or select or section or even the rules and section numbers, but the content is what is important, and a good summary of the content will generally be sufficient. You should be guided by the instruction in the study guide and in the activity questions. For example, sometimes you will be required to note the procedure as prescribed by the rules, and on other times, you will simply need to write down the type of claims that could be given rise to the use of a particular procedure. However, what is important is that you integrate the reading materials with the study guide contents. Unless expressly stated to the contrary, reference to rules or rules with capital letter R, constitute reference to the uniform rules of court, whereas reference to rules or rule with the small letter R, followed by a number, constitutes references to the magistrate's court rules. The section compulsory reading material contains the extract references to the various rules of court or legislation that relates to a particular study unit, except from the page to be studied in the textbook. Now, the tutorial matter that comprises the study unit, you will find it difficult to understand the tutorial matter without simultaneously referring to the compulsory reading material. And it is also important to remember, ladies and gentlemen, that the study guide merely supplements and or clarifies the information in the textbook, your textbook for civil procedure. It is essential that whenever directed to do so, you consult the relevant legislation and court rules when you are working through the study guide. There's an activity which is important to establish whether you will understand and are able to integrate the readings. And also there are the related feedbacks to your activities at the end of each study unit. Now moving along, study unit 1, which is about classification of civil procedure and its place in the legal system. Now the learning outcomes, we will start with the learning outcomes of the study unit. Okay, after studying this study unit, you should be able to discuss the classification of civil procedure within the legal system as a whole. You will explain the basic difference between substantive and adjective law. You will have to distinguish broadly between civil and criminal procedure and ultimately explain the function of the courts. Enforcing the law between legal subjects and the state is the function of the court. The court will hear the presentation of evidence and arguments of both parties, and they are controlled by formal rules. The decision of a court is enforced by the state. Where do we classify civil procedure within the legal system of South Africa? At this early stage, it is important to understand that civil and criminal proceedings may be described as formal rules of dispute resolution that are sanctioned or rather enforced by the state. Civil procedure is divided broadly into substantive and procedural law, or you can say adjective law. Now, substantive law determines or defines the content, a legal subject or a person's legal rights, and legal subject or person's duty and remedies. I hope, ladies and gentlemen, I've explained it quite clearly, or let me rather repeat. Substantive law defines the content, a legal subject, or the content of a legal subject, or rather a person's legal rights, duties and remedies. Therefore, this is the substance of the law that describes the nature of these rights and duties, the manner in which they are established, what their legal effects are, and how they are terminated. There's an example, ladies and gentlemen, in your textbooks, in your study guide, that says, for example, if X owns a motor vehicle, substantive law determines what is meant by ownership, how it arises, the rights and duties of the owner, and how ownership is terminated, for instance, by way of sale. Now, adjective law or procedural law, however, deals with the procedure to be adopted in order to enforce a right or duty and remedies available. It regulates how these rights and obligations are enforced. It deals with the how of the law. For example, how do I claim or how do I enforce what belongs to me, or how do I get compensation for what I have lost or what has been destroyed? Maybe we may be dealing with a contractual claim or a delictual claim. Please hold on for me. I'm getting the next slide. Okay, sorry. To turn to our example earlier on, for example, X lends his car to Z. I'm explaining the procedural law aspect now. When X lends his car to Z, who refuses to return the car because Z also has a claim towards the car. Procedural law sets out the procedural steps that X must follow to regain possession, in which court he must institute proceedings. This means X and Z will deal with the procedures to be adopted in both their claims and what evidence will be required to prove the claims. Therefore, redress in court is achieved by instituting and defending legal proceedings and obtaining a judicial order which can be enforced or executed. The subject matters. The subject matters of court proceedings can be either of civil or criminal nature. Civil proceedings relate to a dispute between legal subjects, one of which may be the state or an official of state. More specifically, a dispute of this nature is described as a claim. For example, we speak of claims for damages arising out of breach of contract or delict. A claim of goods sold and delivered that the purchaser refuses to pay for, despite constant demand, or even a claim against the state, as in the case of unlawful arrest. However, criminal proceedings are between the state and an ordinary citizen. The state acts through a prosecutor in the magistrate's court or the state advocate in the high court on behalf of a citizen against whom the alleged criminal offenses has been committed, which is the complainant. Criminal proceedings, therefore, arises only from an alleged transgression of the rules of common law dealing with crimes or statutory provision of the criminal law. Civil and criminal proceedings rely on different aspects of substantive law and are based on different procedures. It is required possible for a person to lay a criminal charge and institute civil proceedings on the same course of action. An example, if D, from your study guide, if D assaults G, G may lay a criminal charge against D. Sorry, G may lay a criminal charge against D on the grounds of assault and may also institute civil proceedings to claim compensation for the personal and monetary damages allegedly incurred. Before I carry on with this discussion, I would like to go back to the rules of civil procedure. The rules of civil procedure also governs the conduct of a trial, the process of judgment, various available remedies, and how courts and clerks of courts are to function. With this in mind, please note that there are three phases of civil procedure, and they are the pre-trial phase, the litigation phase, the post-litigation phase. Now, briefly, the pre-trial phase starts with a client visiting you as a lawyer with what his issues are and the kind of legal advice he or she wants. To begin, does the client have a case or a course of action? Why is my client suing? And are the elements of a breach of contract present, for example? This takes us back to the substance of law of defining the content of a right and obligations between legal subjects. Secondly, does your client have a locus standi? Very important, ladies and gentlemen. Is the client the correct person to institute a claim because you cannot be acting on behalf of someone else? And also, when you sue a company on the basis of a contractual obligation, you sue a company as an entity, but not a person. Locus standi, ladies and gentlemen, deals with whether the person suing is the person the right person to sue, and also does the person have a mental capacity. So there are 4 stages of persons that cannot participate in a lawsuit. They are a minor person, a prodigal person, an insolvent person, and a mentally unfit or insane person. The issues of jurisdiction. In what court are we going to institute the matter? In other words, which court is competent to hear the matter? Now, in the magistrate's court, consists of district courts and regional courts. The district court have jurisdiction over minor criminal matters and civil matters up to the value of 200,000. The regional court has jurisdiction over family matters like divorce, maintenance, custody matters, and civil matters between the amounts of 200,000 to 400,000. Now, the high courts maybe also be the court of first instance and can be a court of appeal from the magistrate's courts. It attends to civil and criminal matters and matters involving a person's status. Excuse me, ladies and gentlemen. Okay, back on the pre-trial phase. Then ultimately a lawyer will draft a letter of demand on behalf of a client once the above 3 steps that I have mentioned, which are your whether a client have a cause of action, locus standi, and jurisdiction. So your lawyer will draft a letter of demand on behalf of a client once all those 3 steps are dealt with. Thereafter, a claim will be instituted and exchange of documents in support of a claim between parties or lawyers. Now, moving on to the litigation phase. In court, there will be an open statement, an examination in chief, cross-examination of witnesses and expert witnesses, re-examination of witnesses and expert witnesses, and a finding of court. Now that explains the litigation phase briefly. Now the post-trial phase deals with the execution or enforcing of a judgment, costs of litigation paid by parties, rescission of an order, an appeal, and a review of the findings. Okay, I was quite behind with my slides, but this slide highlights briefly what I have just explained about the stages of litigation. Okay, yes, even this one and also the post-litigation phase. Excuse me. Okay, ladies and gentlemen, earlier I introduced to you a claim that can be instituted depending on the nature of the claim. I would like to expand more on their interpretation. In action proceedings, there are 3 types of summons. I said earlier on there were 2, but actually there are 3 types of summons, ladies and gentlemen, which are your simple summons, your combined summons, and your provisional sentence summons. Now, the simple summons is a summons which is not accompanied by any other document setting out the details of a claim. This type of summons sets out the plaintiff's case in a very basic manner. It is used mainly when the claim is based on a liquid document or a liquidated claim. For example, an acknowledgement of a debt, a rendering, an account, delivery of goods, cancellation of a contract, a cancelled contract rather, claim for transfer and ejectment or recovery of the possession of a title of land. Regarding the liquidated claim, ladies and gentlemen, the amount may be determined by a mathematical calculation of the value in question. Now, combined summons is a summons accompanied by particulars of claim, which is another document, ladies and gentlemen. Hence the word combined summons. It is an unliquidated claim or an illiquidated demand, which must be determined by court after hearing of evidence or even the status of a party is affected, or even where the status of a party is affected. This is because there are serious factual disputes that requires the leading of evidence. Now, provisional sentence summons. It is an extraordinary procedure, ladies and gentlemen, aimed to assist a creditor armed with prima facie proof or evidence to recover his money without resorting to the illiquid summons proceedings. Notice that the course of action is based on the liquid document. The document where a debtor acknowledges by means of a signature his liability for the payment of an ascertainable amount of money. After the provisional sentence judgment is rendered, the proceedings goes back to normal procedure by either combined or a simple summons. In motion proceedings, there are 4 types of application. You can either call them motion or application proceedings, ladies and gentlemen. There are 4 types of application procedures, and they are ordinary application, ex parte application, urgent application, and finally the interlocutory application. Now, I'm briefly going to explain each and every one of the applications. Okay. The nature or the cause of action is due to a right which is violated and you want to protect or enforce the right. With the ordinary application, there is a notice of the proceedings to the other affected party to the proceedings. Now, the ex parte application is an extraordinary application where there is no notice to the other party because only the applicant is affected by the matter before the court. An example will be an admission by the High Court as an attorney. And also, it is important to note that the ex parte application order may be granted without waiting for the other affected party to respond, if any. The court will grant a temporary order with the rule nisi that determines the return date to hear the other affected party before a final order may be granted. The interlocutory and urgent application takes place based on a fact contained in a supporting affidavit on the proceedings that has already commenced, ladies and gentlemen, which relates to matters before court. The court will put proceedings on hold and deal with the matter of interlocutory or urgent application. Set the matter down and return to the ordinary application or action proceedings. An example is in an action for a divorce, and there is an issue of child maintenance. And another example is where a parent intends to take the child away from the other parent without the consent. Moving on to service. Serving of documents must be served by a court official of the court to the other affected party, the defendant or the respondent, depending on the type of proceeding. There are 3 types of service, which are your personal service, the edictal citation service, and substituted service. Briefly, personal service may be effected by serving the document personally to the affected party or a place of work. Substituted service is effected when a person is believed to be in the Republic, but his exact whereabouts are not known. The edictal citation is effected where a person is outside the country. Parties to litigation. The respective parties to civil and criminal proceedings each have different roles and objectives. In criminal proceedings, the parties are the state and the accused. The person who has suffered as a result of the criminal conduct of the accused is called the complainant, sorry, ladies and gentlemen. In civil proceedings, the terminology differs according to the type of procedure involved. In matters commenced by a summons, the person, the person who starts the proceedings by issuing a summons is known as the plaintiff. The person against whom the summons is issued is called the defendant. Wherever proceedings are brought on application, the person bringing the application is known as the applicant, and the opposing party is called the respondent. If the matter goes on trial, the person who lodges the appeal is known as the appellant, and the other party as the respondent. Honors of proof in civil litigation. The burden of proof is on the balance of probabilities, and on criminal proceedings is on beyond all reasonable doubt. Moving along to study unit 2. Okay. The learning outcomes are that after studying this study unit, you should be able to explain the main statute that are sources of civil procedure for the purpose of this module. You will identify who has the competency, excuse me, ladies and gentlemen, the competency to make, amend, or repeal rules of court. You will be able to describe the nature of the rules of court and interpret important common law sources of civil procedure. It is important to remember that the Constitution of South Africa serves as the supreme law of the Republic, and any law that is inconsistent with it, may be declared invalid. Therefore, legislation must be studied with this in mind. Okay, sources of civil procedure in South Africa are to be found in the Magistrates Courts Act and Rules, the Superior Courts Act, which repealed and replaced the Supreme Courts Act, the Uniform Rules of Court. Jurisprudence has also been built up around their interpretation, court practice rules, and other legislation. Notice also ought to be taken of the Constitution of the Republic of South Africa, and the Rules Board alone has the competency to make rules of court. So I would like to emphasize that the statute are the main statutory sources for the purpose of civil procedure, which are also Superior Courts Act 10 of 2013, which replaced the Supreme Court Act 59 of 1959. The Magistrate Courts Act 32 of 1944 and rules, and also the Constitution of the Republic. Ladies and gentlemen, apart from acts mentioned above, also as referred to as the primary legislation, court rules that regulates the conduct of proceedings in various courts have been promulgated. They are the so-called subordinate legislation. These rules must therefore be read in conjunction with their particular acts. Okay. Again, the Constitution, as the supreme law of the Republic, provides the overarching framework for civil procedure. The Constitution has been responsible for the significant changes to civil procedure since its inception in the 1990s. For example, debt collection matters, access to the courts and prescription, and in particular with respect to litigation against the state. Prior to 1965, various divisions of the then Supreme Court had different rules of courts for different divisions, and also under the provision of Section 49(2)(a) of the Supreme Court Act of 1959, which is now repealed and replaced again by the Superior Courts Act, ladies and gentlemen. In 2013, the Superior Court Act was passed to rationalize, consolidate, and amend the law relating to Superior Court Act. Superior Court, of South Africa. Unlike the Magistrate Court, the civil procedure of the High Court or Superior Court does not consist solely of statutory provision and rules of court. A substantial part of it consists of common law rules, ladies and gentlemen. These courts do not depend solely on statutory provision and rules of court, which means they have inherent jurisdiction. Although statute in certain cases may limit or increase the jurisdiction of the superior courts. In other words, a court may condone any procedural mistake or determine any point of the procedure. Okay, moving along. Section 25 of the Magistrates Court Act of 1944 provides for making, amendment, and repeal of the rules of the Magistrate Court. As you progress with your studies, ladies and gentlemen, or enter into practice, you will discover that there are additional statutory sources that provide for the procedure in special courts. There are also numerous statutory provisions that confers jurisdiction on a court. For example, See Section 2.1 of the Divorce Act 70 of 1979, which will be discussed later in your study guide, specifically study unit 10. Now, finally, ladies and gentlemen, we are getting to the end of this discussion. The rules of court and the competency to make rules. The background information of the important changes that occurred in 1985 is very important to understand the competency to make, amend, and repeal the rules of superior court and the lower court. The uniform rules of court were promulgated to regulate the conduct of proceedings in all provincial and local divisions of the then Supreme Court. Proceedings of the uniform rules of court were conducted uniformly in all divisions of the then Supreme Court, now the higher courts, under a common set of rules. The effect, or rather the outcome of these rules, was to repeal all previous rules of the various divisions of the then Supreme Court, except those rules of particular division regulating court terms, vacations, sessions, and set down, which remains a matter which exists as the rules for specific high courts. Now, in 1985, the Rule Board of Court of Law was established with its power to make rules for the Supreme Court of Appeal, various high courts, as well as the rules for the Magistrate Court. Section 6 of the Rules Board of Court of Law Act specifies the powers of the Rules Board to make, amend, repeal or revoke or cancel rules for the efficient, expeditious, and uniform administration of justice in the courts. The rules of court for both courts contain annexures that set out the forms prescribed by the rules. These forms contain the wording of various processes mentioned in the rules. This is done for the benefit of litigants and legal practitioners, as well as to maintain uniformity and consistency. Okay, this is section 6 of the Rule Board for Court of Law. And also, in conclusion, ladies and gentlemen, I would like to read through on the slide that students don't read questions properly. For example, the name of the procedure, application of the question in the High Court, procedures and lower court procedures, and vice versa. It is important, ladies and gentlemen, to read your questions very carefully in order to provide a clear understanding of your readings, and also to be marked correctly with your questions. Application of the rules and section to given sets of facts, for example, application of uniform rules, and answers must be specific. They should not be vague, and also motivate your answers fully in order to be marked correctly. Ladies and gentlemen, when you are dealing with the High Court procedure, state relevant sections or rules and apply to the given facts. And in the lower courts as well, state the sections or rules and apply to the given facts correctly. So it is important, ladies and gentlemen, that you provide a clear understanding or a clear discussion when providing a question, an answer, sorry, ladies and gentlemen, to the questions during your assignments or even during your exams. So I hope actually that I've done enough in order to highlight or to give you a clear understanding of what civil procedure is all about. And this is the end of my discussion. And also be on the lookout on the announcement for the next discussion, online discussion class. Either using the Teams Live or the normal Microsoft Teams. Okay, and kindly note, ladies and gentlemen, that, okay, I'm looking at the questions, which are not many. Okay, someone is asking whether the lecture will be recorded. Yes, it is recording as we speak. It records automatically and it will also be posted on MyUNISA. The link will be posted on MyUNISA, or the recording rather, and also the recording and also the Q&As will be published on MyUNISA. Okay, the pre-trial same as take. Yes, someone is asking whether the pre-trial is the same as taking a consultation. Yes, ma'am. As I have explained, it's the pre-trial deals with mainly with when a client is visiting a lawyer and setting out the cause of action, and until you get to your lawyer writing a letter of demand, excuse me, and also instituting a claim on your behalf. Okay, let me publish the questions. Okay, the class is recording, yes. Okay, kindly, ladies and gentlemen, note that further questions will be, answers to questions will be provided on the MyUNISA under either discussion forums or firstly with the announcement on the MyUNISA. And thank you very much for your attendance, and I will end the class now. Have a wonderful day, and I wish you a good and successful completion of your module. And also be on the lookout for further classes, as this is the first of many classes that will be provided by your lectures for civil procedure. Have a wonderful day, and thank you for attending the session rather. Thank you, bye.